And to talk a little bit about drunk driving cases or OUI cases in terms of they're very triable cases, and some advice obviously is don't drink and drive. However, a lot of the times if you have anything to drink, a police officer is going to make an assumption that you're under the influence, and once they smell alcohol on your breath, there's a very good chance that they might arrest you. One of the things that you have to be conscious about is it's not a crime. Might not be smart, but it's not a crime to drink and drive in Massachusetts. They have to show that you were operating on a public way, and that the alcohol impaired your ability to drive safely. There's some different rights that you have. If the officer does pull you over, they give you the opportunity to take something called field sobriety tests. That is something that you have the choice of whether or not you want to do that. You can refuse to take the field sobriety tests, and if you choose to, and they cannot use that against you. Field sobriety tests can be a finger to nose test, or 9-step walk and turn on heels, standing on one leg, doing the alphabet, things of that nature. Some of the time people can be nervous and not necessarily under the influence of alcohol. Other times people just are not as coordinated. They don't give you these tests to drive or to get your driver's license, but having a police officer pull you over in the middle of the night and asking you to do this by the side of the road can be ones that people are just not comfortable doing. So you do have the right to choose not to do the field sobriety tests. In addition, you don't have to answer questions that they're asking you. You have the right to remain silent if you wish to. You do have to give them your license and registration. If you are arrested, you have the right to take a breathalyzer. However, as people may have seen with some of the information that's now in the media about the reliability of the breathalyzer, they will give you a statutory right sheet, and you can take the breathalyzer. Depending on what you get, it can be one that if you get a low enough one, that you won't get charged at all. However, typically people that take the breathalyzer get above the point 0.08 or above and end up getting charged, and it ends up being evidence against them. Again, you can still attack it, but you have the right not to take the breathalyzer. You do have a right to have your own blood test taken, which is a lot more reliable. The reality of it is sometimes it's not easy if you're not bailed out to get the blood work done, but that is an option as well. Again, with OUI cases, if you're charged, even some cases that do not look like they're easily winnable, are cases that are fairly fact specific, and that a lot of different things can mean assumptions. So if somebody sees that your eyes are red and glossy, can that be a sign that you were drinking too much? It could, but it could also be a sign that you were up too much, you were in a smoke-filled room, your contacts were bothering you, you have an eye stigmatism, things of that nature. So almost anything, if you get out of the car and your balance is not great, can that mean again that you're under the influence of alcohol? Yes, but it can also mean that you're nervous, or that you slipped, or that were on pavement, or that some people walk really well, some people don't. There are a lot of different reasons for almost everything that occurs, and they're fairly triable cases, meaning that the Commonwealth and the state has to prove the case beyond a reasonable doubt, which means to a moral certainty. And a lot of the time, if there's not a high breathalyzer reading, and sometimes there are videos, but depending on how the video is, it may end up helping you or hurting you. But they're very fact specific, and they're very, very triable cases that you can go to trial on, even sometimes where you're not sure whether you should go or not. Talking to an attorney will help you